Hello and welcome back to Chapter 7, Consideration and Form, Part 7. Alright, so, Part C, Formalities, Promise under Seals. Long ago, contracts were made by dripping a drop of hot wax on the contract and imprinting it with a family crest on the wax. This would mean that both parties have consent to the terms of the agreement. A party under seal is one exception to the requirement of consideration. Any contract made under seal are valid contracts even though it lacks a valid consideration. Alright, in the case Friedman Equity Development Inc. versus Final Notes Limited 2000, 1 SCR 842, Section 20. The document under seal is well defined. Quote, okay, I quote, because a contract under seal derives its validity from its form alone, there are several incidents of such a contract with different from those of a simple contract. The fundamental difference between contracts under seal and a simple contract is in relations to the doctrine of consideration. The law will enforce a contract under seal even without consideration. Therefore, a gratuitous promise, which is expressed in an instrument under seal, is enforceable. There are other incidents of a contract under seal, which may be summarized as follows. Number 1. Where a debtor covenants in a deed to pay a debt incident based in a simple contract. The right to sue in a debt merges in the right to sue on the covenant and is extinguished in law. Number 2. In an action on a deed, a statement in the deed may operate by way of estoppel against the maker of the statement. Number 3. At common law, only person made in an instrument under seal as a party to it could sue on covenant in the instrument expressed to be for his benefit. Number 4. The limitation period for an action for a breach of contract under seal may be longer than for a simple contract in some provinces. Unquote. Alright? So, there is a legal maxim that states that a contract under seal is that only the identified parties to the agreement may sue or be sued for the breach of the agreement. Page 258. It is understood that the doctrine of agency, that any contract entered into by the agent on behalf of the principal is legally enforceable on the principal. Agents are able to make binding contracts in the principal's name, and the principal can sue and be sued under the contract. However, an exception to this rule is the sealed contract rule. This rule allowed the undisclosed party of an immune from liability and under an agreement by making sure the agents execute the agreement under seal. Page 258. Alright, so in Litton versus Royal Bank of Canada, a contract accompanied by a waffer was executed without the consent and authorization of the guarantor. It was ruled that the word sealed beside the signature line represents an intention to execute a sealed instrument. Alright, in the Canadian Imperial Bank of Commerce versus Keene, it was held that the guarantee contained the word, the clause and word seal or seal or under seal, okay, or made under seal. So it was held that a guarantee contained the clause or word seal or under seal or made under seal next to the signature line was sufficient evidence to execute under seal. Even though there was no seal attached to it, a person is bound by a signed instrument that describes itself as being signed under seal. Okay, so having the word seal next to the signature line is important to make the contract signed under seal. Alright, you don't need valid consideration for that. And that is the end of Chapter 7, Consideration and Form. Thank you very much. If you have any questions or comments, please send me a message and we'll go from there. Alright, thank you.